Hello everyone, we are Team Bona Fide, and today we will discuss sections 11 to 15 of Electronic Commerce Act of 2000. Are you ready? Let's begin.
Section 11, Authentication of Electronic Data Messages and Electronic Documents. Until the Supreme Court, by appropriate rule, shall have so provided, electronic documents, electronic data messages, and electronic signatures shall be authenticated by demonstrating, substantiating, and validating a claimed identity of a user, device, or another entity in an information or communication system, among other ways as follows. The electronic signature shall be authenticated by proof that a letter, character, number, or other symbols in electronic form representing the person named in and attached to or logically associated, or that the appropriate methodology or security procedures, when applicable, were employed or adopted. The electronic data message or electronic document shall be authenticated by proof that the appropriate security procedures, when applicable, was adopted and employed for the purpose of verifying the originator. Supreme Court may adopt such other authentication procedures, including the use of electronic notarization systems, as well as the certificate of authentication. The person seeking to introduce an electronic data message or electronic documents in any legal proceeding has the burden of proving its authenticity by evidence. In the absence of evidence in the contrary, the integrity of the information communication system in which an electronic data message or electronic document is recorded or stored may be established in any legal proceeding. By evidence that all material times the information and communication system or other similar device was operating in a manner that did not affect the integrity. By showing that electronic data message or electronic document was recorded or stored by a party to the proceedings who is adverse in interest to the party. By showing that the electronic data message or electronic document was recorded or stored in the usual or ordinary course of business by a person who is not a party of the proceedings.
So the next section is the section 12. So it is the admissibility and evidential weight of electronic data messages or electronic documents. So in any legal proceedings, nothing in the application of the rules and evidence shall deny the admissibility of an electronic data message or electronic document in evidence that in letter A, on the sole ground that it is in electronic form. So any data or document that is in electronic form can be an evidence in a transaction or agreement which is also admissible. Letter B, on the ground that it is not in the standard written form and the electronic data message or electronic document meeting and complying with the requirements under the section 6 or 7 hereof shall be the best evidence of the agreement and transaction contained therein. So meaning, an agreement or transaction is not in written form. It is in electronic data message or electronic document meeting in and complying with the requirements of the section 6 and the section 7, which is the legal recognition of electronic data message and the legal recognition of the electronic documents. In assessing the evidential weight of an electronic data message or electronic document, the reliability of the manner in which it was generated, stored, or communicated, the reliability of the manner in which its originator was identified, and the other relevant factors shall be given due regard. So in an agreement or transaction, the reliability of the electronic data message or the electronic document, together with the reliability of the originator and the manner it was generated, stored, or communicated, is very important in assessing its evidential weight.
Section 13, together with Section 6 to 12, is all about giving legal recognition of electronic data messages, electronic documents, and electronic signature. So Section 13, retention of electronic data message or electronic document. Notwithstanding any provision of law, rule, or regulation to the contrary. A. The requirement in any provision of law that certain documents be retained in their original form is satisfied by retaining them in the form of an electronic data message or electronic document to which one remain accessible as to be usable for subsequent reference. So, for example, in obtaining any electronic data of the government or any other organization, one should not make any alteration, addition, or omission of any information that could affect the credibility of the said document. Thus, it should not be restricted and available for future uses. 2 is retained in the format in which it was generated, sent, or received, or in a format which can be demonstrated to accurately represent the electronic data message or electronic documents generated, sent, or received. So electronic document and data should not be converted in any other means such as publishing it or printing, emphasizing that in whatever form it was generated, sent, or received, it should be remain. And 3 enables the identification of its originator and addressee, as well as the determination of the date and the time it was sent or received. And B, the requirement referred in paragraph A is satisfied by using the services of the third party provided that the conditions set forth in paragraph 1, 2, 3 as discussed earlier of paragraph A are met.
The next section is section 14, proof by affidavit. The matters that are referred in section 12, admissibility and evidential weight of electronic data message, and section 9, presumption relating to electronic signatures of this law is presumed to have been established by an affidavit. An affidavit is a written statement from an individual which is sworn to be true. It is an oath that what the individual is saying is the truth. Upon those matters, a written statement in the form of an affidavit shall be established and given to the deponent or a person who makes a deposition or affidavit under oath. He or she shall have knowledge in terms of the rights he has as defined in the sections mentioned above. So the next section is section 15, cross-examination. So let me first define what is cross-examination. In law, cross-examination is the interrogation of a witness called by one's opponent. The function of cross-examination is to test the truthfulness of the statements of a witness made on direct examination. The opportunity of cross-examination has been regarded as an essential safeguard of the accuracy and completeness of a testimony. So under section 15, 1. A deponent of an affidavit mentioned in section 14 may be cross-examined as of right by a party to the proceedings who is adverse in interest to the party who has introduced the affidavit or has caused the affidavit to be introduced, and 2. Any party to the proceedings has the right to cross-examine a person that is referred to in section 11, paragraph 4, subparagraph C of this law. That is all about our discussion for sections 11 to 15 of the Electronic Commerce Act of 2000. This is Team Bona Fide. Thank you and God bless everyone.